Hey guys, welcome to On the Docket with the Fab Attorney. How are you guys? I hope you're doing great. I'm doing very, very well. I know it's late, but girl has a law firm to run, trials, life is lifing. So yes, let's jump right into it. I had to jump on the Donna Adelson trial is going on right now. I'm so fascinated. For those of you who do not know, I am a trial lawyer. I spent the earlier part of my career doing criminal defense. And now I own and operate a divorce and family law firm here in the state of Florida. We take some cases in New York as well. I feel that that makes me uniquely qualified on this case. So years ago, this case has been going on for a while when Dan Markel was gunned down in his driveway by a hitman. And the basis, it was a big, there was a lot of noise about this case when it happened here in Florida. This is in Leon County. I'm located in Orange County, like Central Florida. But there was a lot of hoopla about this when it first happened. And essentially the basis, the genesis of the motive for murder, the conspiracy, for the hiring hitman and killing this young professor, very gifted, was a custody battle, a divorce, and uh, Donna is the grandmother to Wendi. Wendi was married to Mr. Markel. They had gotten a divorce, and Wendi wanted to move to South Florida where her family, her mom, her brother, and there was a dental practice could be. And her family was very much so invested in the grandbabies and nephews coming to the South Florida area to the point where they hired a hitman, two hitmen, Latin King members, to kill Mr. Markel. He was shot dead. Okay, he was shot dead in his driveway. He's a professor. And as we sit, this emergency hearing happened August 18th that I'm going to be talking about. We're going to be watching footage. And just know at the heart of it, I am a trial lawyer. So I'm not just talking about this from a theoretical standpoint. I have been in these trial streets as a criminal defense attorney and as a divorce and family law attorney for over a decade. And I love trials. I love trial work. I love to see how the criminal and just the civil system works. So that's what we're going to be breaking down here. And I also just think that this case has all the elements, custody battle. Um, Wendi wanted to move to relocate, and Mr. Markel, her former husband, was opposing it in court. And that's when he was shot dead. And it is that serious. Sometimes it is that serious. It's very dangerous. It's every family divorce lawyer's worst nightmare that this would happen and that people would take it this far. And it has. So as we sit here today, uh, the brother to Wendi, which was the wife, has gone down. He's serving life. His girlfriend, who facilitated paying the hitmen, the Latin King members, to kill Dan Markel, she's in jail too. And hitmen, they're in jail. And the last of the Mohicans, so to speak, is the sort of matriarch of the family, Donna and Wendi. And the basis of the motion to quash, which is what the hearing was about, is that Donna's defense team is calling Wendi, her daughter, to testify on her behalf, if she's calling the witness, right? As a defendant, you have no, um, you don't have to put on a case. It's for the state to prove the case. In this situation, the state has proven these facts with other defendants 4 times. So it's not looking good for Donna, who's 75 years old, by the way, 75. And she was arrested while about to board a one-way flight, I believe, to either Vietnam or Thailand, whichever one. And she was stopped. So she's trying to abscond. She's trying to evade the accusations at the very minimum. So the basis of the law, just to sort of, make it vanilla, is that you cannot call, the defense doesn't have the same protections of immunity that the state, the prosecuting attorneys have in Florida. And I think this is in every state. There's three types of immunity. Two, if the state is calling a witness, two types of immunity is sort of bestowed upon that witness at the state's discretion. One is use immunity. So the use of immunity is that the state is unable to prosecute the witness that they call for anything that they testify about at whatever the hearing or trial is. Second one is derivative, immunity. So not only the testimony, but any evidence that can be derived or that can be born fruit of that testimony, right? So if something's testified to and it says, oh, we used to take vacations and, Martha's Vineyard, and I think, maybe that's where the body is. And then they find the body, you can't now, the person who's testifying cannot be held responsible illegally for anything that is incriminating. So only the state, the prosecuting attorneys have that ability to provide that immunity. In this case, Donna Adelson's defense team is trying to call Wendi, and Wendi is shaking in her boots, as she should be, because I think they're gonna bring charges against her. I think they're waiting for her to be the last person the charges are brought against. And the premise is, in terms of the law, is you can't think about being a juror. You can't call somebody when it's understood and known that anything that you possibly can ask that person on the stand is going to elicit them taking the Fifth Amendment right. So that's very dramatic. You call a witness, and the witness is your daughter, and the witness's husband was shot dead in his car. As we sit here, the daughter Wendi has moved states and changed the names of the children, right, to protect them. And she testifies, Wendi testifies, or is called to testify, but all she does is plead the Fifth Amendment. That in and of itself, for a juror, is reasonable doubt. Like, wait, it caused all kinds of thoughts of like, wait, why is she not wanting to testify? And that being the case, that's why the state is moving to quash. Okay, so quash, cute legal word. They're moving with a motion in front of the court, and they want to quash the subpoena. So the subpoena would command somebody under the order of the judge or the subpoena itself to have to come and testify in court. They want to quash it to where it's moot. It has no power, has no teeth. And I want to kind of just look at what happened. I have not looked at this hearing at all. I've been in court all day myself. That's why this is rather late. That's why we're recording now. But let's get to the. Okay.
Appearances on the record.
Georgia Kappelman and Sarah Catherine Dugan for the state.
Joshua Zoman and Jackie Fulford for Mrs. Adelson.
Good afternoon, Your Honor. John Morrow on behalf of the witness Wendi Adelson, and my colleague Matthew Luca is with me as well.
Good afternoon. I have reviewed your motion, Mr. Loro, concerning the defense's subpoena as far as placing a statement on the record. I don't know if any of the parties have a position concerning you placing a statement on the record, but similar to the other trials in this matter, I do not have an issue if you do so prior to the testimony of your client. As to the placing the statement on the record, does the state have a position?
No objection, Your Honor.
Does the defense have a position?
No position, Your Honor.
Concerning placing a statement on the record, Mr. Loro, you will be permitted to do so, or another member of your firm, before your client testifies. As to the motion to quash the defense subpoena, does the state have a position?
No, Your Honor, no position.
Does the defense have a position?
Yes, Judge.
Go ahead.
May I stay here?
You may.
Judge, the issue here and the concern that we have on behalf of Mrs. Adelson is there have been 2 prior rulings in the homicide of Mr. Markel. One came from Judge Hankinson, and then another one came from Judge Wheeler. What Judge Hankinson ruled is that the immunity conferred by the state subpoena extended to cross-examination, and we believe that's an accurate statement of the law. However, Judge Wheeler limited cross-examination to only what the state brings forth on direct. This is a premature at this point, Judge. We have her under subpoena, and we may want to elicit testimony from her.
Well, before we get there on that point, when she's called as a state witness and she is cross-examined, she can be cross-examined on all matters raised by the direct.
So this is getting very evidentiary, and it's very, I'm an evidence nerd. So essentially what the attorney has says is a defense attorney, the lady with the short blonde hair standing up, and she's arguing her motion on behalf of her client, Donna Adelson, in this matter. Long and short of it, to keep it super simple, these similar arguments have been brought in front of 2 other judges than the judge that's in front of us here in the video, and both have made a ruling. So she's highlighting that, and the evidentiary thing, and it's like the law nerd thing, is that the state is calling Wendi, Donna's daughter, and when she's testifying for the state, she is under the protection of this whatever immunities the state is offering her. I'm sure there's an agreement in writing. And the defense wants to call Wendi as their own witness and go outside the scope of the testimony or that's elicited from the state. And usually when a witness is called by one party in a criminal matter, whether it's the state or the accused, cross-examination is limited to topics or facts that were brought up in the direct examination. You can't go beyond the scope, is what it's called. You can't go beyond the scope. Here, they want to call her as defense witness as well. So when she's on the stand, she'll both be the state's witness, and then she'll later be defense witness. And they're trying to convince the judge to allow testimony outside the scope of what is elicited, and therefore protected by the immunity of the state. So I think that that's fascinating.
And on matters of bias or impeachment or motive to lie, all matters that she can be cross-examined on pursuant to the rules of evidence extend under that state subpoena.
I understand that, Judge, but our issue is, suppose that she's one of the first witnesses to testify, and suppose after she testifies, other issues come up that we know if we called her, she could rebut what has been said. It's not necessarily, it would be something that she would need to invoke her rights. It could be a very simple issue, and we would need her testimony. So until we go through the trial to see what happens, it's impossible for us to say, yes, just cross-examining her on bias and credibility and whatever the state has asked about sounds good in the state's case until we hear further testimony and some issue arises.
I'll allow Mr. Lawyer to make his argument, but the crux of his motion is you cannot offer this witness any protection as it relates to you calling her in your case in chief. What is your response to the written argument on that matter?
Yes, Your Honor.
Hold on, Mr. Lawyer. I'm going to allow Ms. Fulford.
Oh, I'm sorry. I thought you were asking me. I'm sorry, sir.
You can make your argument in just a moment.
I love how this judge, he's no nonsense and he takes command of his courtroom. No games to be played here.
So the issue as to immunity, we cannot confer immunity to her, Judge. We agree with that. We can't. But there may be other issues where she could testify to something that she's not taking a chance, if you will, that she's going to say something that could be used against her in the future. There could be other matters that are raised in the trial that we simply want to get testimony from her as. She is the daughter of our client.
From the perspective of your client, I certainly understand the argument you're making. Mr. Lauro, you may argue.
I think it's a very narrow legal issue, and they're asking the judge to speculate and sort of give them the defense. If there is an issue that comes up that's not going to evoke Wendy's evoking her Fifth Amendment right not to self-incriminate, that can they have leeway because she has a relationship with Donna as a daughter, so there may be other topics, character things she can speak to. She should be able to testify on those things potentially, and they've conceded because it's well settled. They can't convey any type of immunity to her as defense counsel.
Yes, Your Honor, this issue was addressed by Judge Wheeler in the second McBanamour trial. It was also decided upon by the first DCA in July 2025, when the DCA ruled that the procedure used by Judge Wheeler was entirely correct, and the subpoena in that case was quashed. It was the same issue that the defense raised, where they wanted to cross-examine my client pursuant to a defense subpoena, which conferred no immunity at all on Ms. Adelson. I indicated to the court then, as I will now, that Ms. Adelson will assert her Fifth Amendment rights with respect to any relevant question asked by the defense. So the only result of the defense procedure would be to have the client's daughter take the stand and invoke the Fifth Amendment in front of the jury. And that the court decided by Judge Wheeler that would be inappropriate. And we would ask the court now to follow the same procedure as Judge Wheeler and follow.
And I want you guys to really appreciate what's being argued here. Essentially, and I've done lots and lots and lots and lots of trials. So specifically in front of jurors, imagine what the state attorney is saying is that either through interviewing Wendi or deposing her, they've come to understand that her position is any question the defense counsel asks her, she's going to invoke the Fifth. Okay. And because they understand that, it would be very detrimental to the state's case if she's able to take the stand and invoke her Fifth Amendment right. That in and of itself can be reasonable doubt to a juror, because then the juror is going to say, well, is she trying to say she's responsible? Mom might be innocent. So the state is going to fight this, tooth and nail, because it's very, very, very key that they win on this issue as to avoid their potentially being, theatrics in the courtroom that take away from their case.
Under the same procedure that was upheld by the first DCA just 1 month ago.
Does the defense have any remaining argument on this matter?
Your Honor, respectfully, the issue that was ruled on or concerning the subpoena and quashing the subpoena, Ms. McBanamour did not make that argument below. She did not join the state's motion. So the first DCA did not rule that Judge Wheeler followed the proper procedure. My understanding is that the first DCA held that she had not preserved the argument.
And if I could add one thing further.
We don't have tag team motions. Who's going to finish the argument?
And this is just a little trial nerd thing to know. If there's multiple attorneys and there is an argument taking place, one attorney has to be the spokesperson. You cannot tag team. It's something that's in, courts doesn't like. The court doesn't allow, excuse me. It is almost midnight. This is just terrible. Look at her, 75 years old.
Your Honor, factually, we're in a vastly different circumstance. Our client certainly has information, knows information about her daughter that Ms. McBanow would not have ever been able to know. And so it's our position that it's premature. The Fifth Amendment question, the courts have ruled, should be done on a question-by-question basis.
So your expectation is for me to ask the question, she will make some sort of signal, I'm invoking, the jury is to be removed, and then we do this for the entire defense direct?
No, Your Honor. What I would suggest is that if we get into this posture, and absolutely cross-examination.
And you can hear the sarcasm dripping from the judge. The judge is very stoic, but he's like, so you want to waste the court's time? Let me tell you one thing about judges. They do not like to waste time. Essentially, the judge is saying, so you want us to let you ask every single question on your direct or cross of Wendi and then remove the jury each time so they don't hear her invoke, right? In the interest of fairness. And let me see, Miss Chocolate, that's great. They should be able to question her, the killer, and the chick mentioned her name as in she has something to do with it. I think, listen, if we're going to get into that, Miss Chocolate, and thank you for being my first comment. Hey, girl. The law is, the law is the law. They should be able to question her, and I want to do a better job of teaching the law is not common sense sometimes, right? They should be able to call her and question her for sure. But the Fifth Amendment is a constitutional right? And so obviously we have armed forces and everything that guards our protection under the Constitution. And so what has happened here, you may not heard this, I said this a little earlier, Miss Chocolate, is that the state attorney has already either deposed or interviewed Wendi, and she has communicated to the state that she's going to invoke her Fifth Amendment right, no matter what what the defense asks her. They ask her, hey, is today Wednesday? She's going to say, I invoke the Fifth, because she does not want to go to jail. She is down bad, okay? Because everybody else who's in her family and was a part of this conspiracy is doing life. I think one of the hitmen, he's doing 19 years, but everybody else is doing life. So she is scared, and she should be scared. They're coming after her. I think they're going to get her, Miss Chocolate. Great point.
May be sufficient. But if we get into the posture of needing additional, I would suggest that potentially proffering the questions, and then she and her counsel can advise the court if she intends to invoke her privilege at that time.
Mr. Laura, last word, and then I will rule.
Yes, Your Honor. The statement by counsel is patently incorrect and false. This issue was raised by Ms. Carras in the McDonald trial. She preserved the issue. She made the same arguments that these defense lawyers are making now. It was wholly rejected by Judge Wheeler and wholly rejected by the first DCA. And we respectfully request that Your Honor follow that ruling here. There's simply no question that the defense could ask that is relevant to this matter that Ms. Adelson, my client, would answer. She's invoking her Fifth Amendment.
Okay, so this is even more juicy, so to speak, legally juicy. Since there's already been 4 trials, the girlfriend, the brother, his girlfriend, and the 2 hitmen, there's already been these same arguments made to other judges and to appellate courts. So when you hear them talking about, the first DCA, they're talking about essentially this judge's boss. They don't want to be overturned on appeal, okay? It makes you look like you don't know the law. So this is the 5th trial on these set of facts, and the first 4 didn't go well. So they are citing the law and the rulings of prior judges with similar facts. And I think that's to the advantage and disadvantage of Donna. I do believe, let's put it on record, they will be coming after Wendi. I think they're just waiting for her last. I don't know what the rationale is. I don't know why they've done it this way. I know that the other co-conspirators are supposed to testify in this trial. And I wouldn't be surprised, mark the date and time, if they offer one of them some type of, and there's things you can do like, oh, I'm going to send you to a lower security jail, or you can have extra, time in playtime in jail, things like that. When you're in a box, people are singing. People are singing. Good point, Miss. It is BS. I do think when something as serious as, and I'm a former defense attorney and I'm a current trial lawyer, and primarily my law practice, we do divorce, family law. And so I've done the criminal cases. That was back in New York, and I am in Florida, and I know what's going on in these courtrooms. And the criminal system is not necessarily about transparency, and it's not necessarily intuitive and common sense. And it's really hard for people to wrap their head around. My best advice, don't get arrested. It's just, there's a lot of it's not as straightforward as people think.
All right. Having reviewed the applicable authority on this issue, and also reviewed the prior transcripts on this matter that were also ruled on by Judge Wheeler concerning this same subject, I am going to adopt a similar ruling. The defense cannot give the witness immunity as it relates to any matters in which she would testify under and could properly invoke the Fifth Amendment privilege. No witness can be called to the stand simply to invoke the Fifth Amendment, as there would be no basis for this witness to take the stand and give testimony on a relevant matter that also could not affect her ability to also endanger her own Fifth Amendment.
The judge is essentially saying that it's his belief that there's no other possible thing that Wendi could testify on that would not be a detriment to her Fifth Amendment right. And that's a huge statement. I'm very curious what the basis of that statement is, because that is her daughter, in the sense of like, maybe she could testify as a character. Maybe she this is just me playing devil's advocate as a trial attorney in my mind. But this judge is not going to get caught legally slipping by his, appellate overseers. He's not doing that.
Right. I am going to grant the relief that is requested. If we need to revisit this issue for any purpose where the defense believes there is a line of questioning that will not go to the Fifth Amendment privilege of the witness, we will at the appropriate time. But I do believe it is
and that's key. He's not completely shutting them down. He says, if you can, it's called an offer of proof. So he's saying to the defense counsel, if you can, you can tell me what your proposed questions to Wendi will be, and if I feel that they are not in violation of this court order, I will allow them. So that's interesting. He's kind of taking a middle of the road position in that sense, because he's shutting it down as like making a general ruling that she can testify. But he said it sort of like, if they can make an offer of proof, he's willing to entertain question by question or line of question by line of question. That's interesting.
the proper ruling at this point to quash the subpoena. Mr. Laurel, I believe that concludes your motion for today. Again, when it's time for your client to testify, you may place your statement on the record.
Thank you, Your Honor. Good day, sir.
To you as well. That concludes the public portion of the hearings for this afternoon.
And I find this to be really fascinating today, and I haven't had an opportunity to look at it. I might take a peek and make another live or video or something to that effect. But I find it, if you're into trials, jury selection is where it's at. I'm a trial lawyer. I've been doing this over a decade in 2 different states. Cases are won and lost in jury selection. If you get the wrong juror on your panel, depending on what side you're on, you need one juror to say not guilty to have a mistrial, and you need all of them to say guilty. But again, everybody's going to have the knowledge that the other four co-conspirators have been found guilty. The other four co-conspirators are set to testify, I'm assuming, against Donna. And they have some really, really bad evidence against Donna. I think they have a jail call where she thought it was hung up and she was saying that she was going to abscond. Things that would kind of indicate her being, guilty in this case. And everybody's wondering about Wendi. I do believe they're going to come after Wendi. I would say definitely look at the voir dire. The questions are essential. Having the right jurors on the juror panel is very essential. If your defense counsel, you want somebody who is easy to go against the grain, who's questions law enforcement, who is like more of a person like, hey, you need to prove this. Prove to me that this woman has done this. I need to see some real good evidence of that. And if you are the prosecutor, just very generally speaking, you want people who they believe police officers across the board, just by nature. They are follow the rule kind of people. If there's smoke, there's fire kind of people. So the questions will be about, do you have law enforcement? They might even ask people if they've gone through divorces or custody battles themselves. And I'm thinking, if I am defense counsel, really, you're going to put the blame on other people. But the issue that they have in this case, and this is fascinating, guys, the issue that they have in this case is that there's circumstantial evidence that is compelling. Okay. And it's not DNA and gotcha evidence, but when you put everything together, and it's one of those things like, if it looks like a duck and it talks like a duck and it quacks and it's yellow, it's probably a duck. So they have that there is a train of phone calls that happen, and the first triggering phone call comes from Donna. I'm gonna call the matriarch. And then it would go to her son. I believe his name is Charles. I can't remember his name is Charles. And then the two hitmen, or the girlfriend, and then the hitmen. And it's like ping, 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 ping. The phone calls. Oh, which husband? There's no husband. The husband's dead. Oh, the husband. I don't think you mean Donna's husband. I don't know. And you know what? He might be one of those. I've looked at the evidence. He might have been out of it. Like the person with the aggressive personality who called shots in that relationship was Donna and not her husband. So I wouldn't be surprised if he wasn't fully aware, if you understand what I'm saying. The phone calls, that's rough, because it's the sequence of the phone calls for Donna, right? She makes a phone call to the brother, then the brother to the girlfriend, his girlfriend, and the girlfriend was the go-between and the hitman. Now, let me tell you something. Perhaps your brother might lie for your son, and perhaps the girlfriend, but those hitmen, they're not going to lie. They don't care. One of them already got 19 years. The type of relationship. These are people with dental practice. They're in South Florida. I already know the vibes. I already know. And she is the one that runs that. And he kind of, he may have known or suspected, but he wasn't calling any real shots. And I wonder what his health is. Remember, these people are 75. I believe Harvey's older. So it could be that, he really wasn't in the mix, but you'd be surprised. Sometimes people don't know what their spouse is up to. Again, divorce lawyer here. They don't know what their spouse is up to. And the crazy part is, well, David, 81. Okay. He might have been a little, I'm not trying to be cute, but he probably didn't really know what 100%. His health is, I'm speculating his health may not be great. Because otherwise, let me see, some prosecuting attorneys are, some of my good friends are prosecutors. I used to be a defense attorney. They're relentless. but they're going to only take the cases that are going to give them a W. And this is a type of case that careers are made out of. So so the prosecutors are fully aware that there's eyes on this case. There's been true crime podcasts and all of that. I actually got introduced to this case watching some kind of true crime show years ago. It could have been a decade ago. It was a while ago. And I was fascinated by it because I'm in Florida. And again, I did criminal defense early in my career. And now I'm a trial lawyer. And I mainly do divorce law. And I understand how nasty things can get. Oh, I said it earlier, David. I do believe when they're coming after Wendi, I think she's going to be the finale. And I think that think about it like chess. They're lining everything up. This is a coup because they want to incentivize everybody to testify against Wendi. When you are in jail, when you are in prison, excuse me, not even jail, and it's cold and it's nasty, and you're in a anything extra time in the play yard, having a nice job, going to a lower security prison, even getting a couple years off of your sentence or a referral to be on probation early. People will, well, literally snitch on their mothers. Literally. So I believe that they've done it in this way intentionally because they're going to incentivize everybody to laser in on Wendi and testify. And they're going to offer each of them different stuff. The way people are with custody, let me tell you something. Custody, the relocation, when I saw that, when I speak to my clients and my potential clients, when they get into this, just this nasty place with their ex, I literally pray and beg them to be the bigger person and try to find middle ground. Obviously not when there's physical abuse, but when people have a little money or a lot of money, and these people were upper middle class, they had some coins, and they, nasty things happen, love things, cheating, lying, whatever. And now you hate the person and you want your child 100% to yourself. I see people willing to do all kinds of things, lie on people, say that they molested children that they haven't, beat people up, try to get people fired from their jobs, try to get people thrown out of the military. It gets so nasty. And this is my biggest fear. This is my biggest fear, like people killing each other. I have been a part of some cases where clients or somebody on the other side killed themselves. It's rough. Like after losing in a divorce or custody battle, it can be really, really rough, and it can bring out the worst in us. So yes, David, I know very well it brings out the worst because people are willing to do anything and everything for our children. And the children lose here. That's why this case is just so sad. Like this child's whole family, I guess, except Harvey, who's 81, and mom, who they're going to come after her. They're going to come after her when they have all their ducks in a row. And they're going to incentivize all of her family and the hitmen to testify against her and potentially her own mother. And they're going to roast. I believe so. I don't know why they've done it this way, because typically they'll go for the person they find to be most culpable. It could be this is how the evidence crumbled. And it could be Wendi is smart like a fox. She could have kept herself out of it. It could be a situation where Donna acted on her own. And it was sort of like an understanding, like, hey, I need this taken care of, but I don't want to know any of the details. And they may not have any circumstantial evidence against her. And because of that, they decided to strategically prosecute in the order that they're prosecuted. And then they're going to hope that somebody is willing, once they're convicted, the mom, maybe the brother hasn't cooperated with the state. Yep. Wow. Yeah. I pray over because it just brings out the ugliness in us. And I think that people don't like, because did the kids win? They don't, did the children win? They're, they live in a social media age. They have to know what's going on. You could change their name, but you can't change their DNA. And they don't, and Dan listen, I don't know how he was inside the marriage. Okay. Cause I can tell you as a divorce attorney, you never know that. But he was a great professor and he was a educated guy, decent looking guy, by all accounts, a good father. He didn't deserve to be killed, at such a young age because somebody wants to move to South Florida. That's terrible. It's absolutely terrible. Yeah. The custody case really, 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 I mean, I see people do the most asinine, and really, I think my work is I always tell people, I'm trying to get you to the other side so you can have a happy chapter. Because when you're in the middle, sometimes people can't see that you're in the middle. You're not always going to feel this way. There's love again. There's even sometimes co-parents who are in a bad place become good friends years later. You have to let time. You really, really have to let time. And I do think, these children just have suffered. I'm going to try to live stream the trial. I didn't see the testimony of not the jury selection. The jury selection is where it's at. You get the right jurors on your panel or the wrong ones, you are up a creek without a paddle, or you've won the lottery. Cases are won and lost in jury selection. You have to get the right jurors. They're in Leon County. I'm really interested to see what the demographic that they're going to be looking for on this jury. $5,000 to kill somebody. Wow. Listen, I had a client, I'm not laughing, pay somebody $5 in a bucket of chicken, a crackhead, to jump her ex-husband. She went to jail. People just really lose. Stay prayed up, guys. People really lose their marbles about stuff. And then you should see, when I see how Donna looks, she just looks so distraught. She's 75 years old. She's not doing well in there. And it wasn't worth it. I think David had a point. Well, sometimes you get a little money, a little education, and you feel invincible. But listen, life will humble you. Listen, David. He said his dad had to. It is stressful. I mean, at this point, I have attorneys that work for me and things like that, and I don't take that many cases to trial and stuff like that. I do deal with the clients. I do the healing part, and I do have a small load of cases I still take, and they're usually the high conflict one. But I think I have the heart of therapists and people like that. I really feel like I help to heal people. It's truly a calling, but it can wear on you because it's not a job where anyone's really happy at the end. Even if you get them everything they want, they're thousands of dollars in the hole and divorced and only seeing their kids half the time. Sometimes they're paying alimony. It's just not a happy time. But my thing is that there can be a happy time after. And I know I'm divorced myself and very, very happy now. So you can be, going through the worst time in your life. And then if you keep on trusting God and keep on trusting, you get to that other side and it gets so beautiful. And you're like, oh my God, I wish I could go back and tell my past self this. I'm going to do live. I'm going to do live. I have to figure this out. Like, I've been wanting to do this for so long, guys. And I'm so glad I have a couple of people because I just can't do it. I actually am running a whole law firm and have things to do. And I was like, well, I can do it late at night, early in the mornings. But this is fascinating to me. And I am truly a legal nerd. I love to see, I like the legality of it and also the human element. And guys, but for the grace of God, go any one of us. And that's sometimes when you see that you're upset about something or something seems like the end of the world, I tell people therapy, a relationship with God, coaching, whatever you need to do. but it's very important that we don't, we found each other tonight. Yes. And I'm going to be consistent with this, guys. I love it. I love it. And I love the law nerds like me, people who love, we're all humans. We're having the human experience. And, you know, we all have a friend, family member that could have been Donna or Wendi Adelson. And I have lots of clients that I'm sure that if they had the $5,000. All right, it is late, and I do have an early morning, and I do want to go live tomorrow. I'm so excited. I'm hoping to build a great community and for us to keep up the discourse. You guys have a fabulous night, and I will see you soon. Bye.